Welcome to the Great Divorce Podcast, hosted by divorce financial analyst and retirement planning counselor Andrew Hatherley. Join Andrew and guest experts as they help late-life divorcees build the financial and mental foundation for a meaningful future. There is life after divorce. Now, on to the show.
Hello, everyone, and welcome to the Great Divorce Podcast. How does mediation in divorce actually work? We've discussed mediation several times on the podcast, along with other alternative resolution techniques such as collaborative law and amicable divorce, but we've never actually gone into the nuts and bolts of how mediation works. To help us understand how mediation works, in divorce, we have with us family law attorney Amber Robinson. Amber is the founder of the Robinson Law Group, a Las Vegas family law and divorce firm, and she is a graduate of the Boyd School of Law at the University of Nevada, Las Vegas. Amber has extensive experience in all areas of Nevada family law, including divorce, child custody and support, and child relocation. Importantly, for our discussion today, Amber and I have worked on several mediation cases together, all of which I'm happy to note were resolved successfully in the sense that the two parties were able to come to a quick settlement and were able to avoid the financial and emotional stress of a protracted divorce. Amber, welcome to the Great Divorce Podcast.
Good morning, Andrew. Thank you so much for having me today.
And thank you very much on this Boxing Day, which for the non-British or Canadian listeners is the day after Christmas, which I think is a holiday for them, which I think is something that we should adopt here in the States.
Right.
Anyway, Amber, let's start out with a quick brief overview of mediation. And I'm curious how you define mediation in divorce.
Well, mediation is negotiation. So in divorce, that would be negotiation on children, child custody if you have children, child support, other expenses for the children. Like, are we going to send them to private school? How are we going to handle all of this? As far as just general divorce with or without children, we usually have some assets to split up. We have debts. We potentially have alimony, and then we potentially have attorney's fees.
Right. So mediation can involve two attorneys, each party being represented by an attorney. And we're going to get into that because that's how we've done our cases. But I wanted to briefly cover there are non-attorney mediators out there, right? And they can work with divorcing parties. And then they might come to an attorney to drop the paperwork, right?
Right. So yeah, there is specifically, I can think of one off the top of my head right now that I refer to a non-attorney mediator when it's relatively simple issues, and I also look at the client's budgets too. But if they're, fairly simple issues, not like a lot of complex finances, I will usually send them to that person because she's quite competent and is that neutral voice in the room. That's what a mediator is. Is there a neutral voice? They don't represent one party or the other. They're there to see if they can work an agreement between the parties.
Right. Now, I've heard the term court-appointed mediators. What does that refer to?
So a court-appointed mediator, well, we have mandatory mediation in family court when we file a case through the Family Mediation Center. So I wouldn't necessarily call them court-appointed, but we do have the duty to go to the Family Mediation Center when there are children involved.
Right.
Sometimes we will stipulate me and the other attorney will stipulate to opt out of that if we know that we're going to go to maybe a regular mediator that can also cover all the finances.
Right. On the Great Divorce podcast, we rarely have minor children involved in these cases. Um, so, what about, and this has happened to me a couple of times, where I've gotten a call, a cold call from somebody who might be looking for legal advice, but they don't have a lot of money and they want an attorney to both mediate and draw up the paperwork for the couple themselves. What do you do if somebody comes to you and says, "Me and my husband are getting divorced and we want to work with you. We don't want any other attorneys." Can that be a functional mediation?
I personally don't do that. I there are some people that do, so I don't want to say that it can't be done. Um, but like I guess I'm not really negotiating. I'll take on those cases where the parties have already worked out the terms themselves, and
Right.
I'll drop the paperwork.
Right.
But I don't ever want to be in that spot where someone thought that they were getting advice when they really weren't,
Right.
and they came to agreements that they didn't necessarily want to come to.
Right. So if I understand it correctly, you can draw up paperwork for a couple who have settled their issues, maybe, as you mentioned, with another mediator, even a non-attorney mediator. Let's say they've gone to this non-attorney mediator, they come to an agreement because their case is very simple, and then they come to you to drop the paperwork. You can do that, but you can't be an advising attorney to two people.
Right.
Okay, cool. All right, so we've worked together on a number of cases, and in these cases, each party has an attorney. I've never asked you this before, so this is going to be educational for me too. Is what's going on in Amber Robinson's office when she calls me and says, "Hey, me and Joe Smith, attorney, have a case we want your help on." What's going on there?
Well, in those cases, the clients usually have a lot of financial accounts and not just your standard bank accounts. They're going to have IRAs and 401ks and stocks. And I know enough to know that I don't know everything, and numbers are not my thing. And as we've discussed multiple times, this financial account is, even though it might look similar in number range to the other financial account, they're not the same because, maybe that other financial account is going to have some tax implications, et cetera.
God bless you, Amber. I wish I wish other attorneys acknowledge that perhaps they're not the financial savants they think they are.
Mm-hmm.
So there's this other attorney involved. So is there ever an issue saying, "Hey, I know this guy Andrew. He's a certified divorce financial analyst, and he can help us." What's typically their response when you mention me to them?
They are usually open to it because they can usually see too the number of accounts and that kind of thing. And I'm thinking about this case that we most recently had. Um, like for example, in that case, there were I
Restricted
think some
stock units.
stocks,
Yeah,
yeah,
restrict
stocks.
RSUs, restricted stock units. Yeah,
So not issued yet, I think. And
not
I
vested,
don't
right?
know anything about that,
Yeah,
and I'm not about to tell a client how to divide that or what is considered not divisible at this point.
right. No, that's great. So, okay, so you call me and you say, "Hey, me and this other attorney, we each represent these parties. We'd like you to be a financial neutral to help us help them resolve their divorce through mediation." I should say, okay, at this point, I like to gather as much information as possible as early as possible. I don't know about other attorney mediators out there, but certainly we're planning to meet on a day, and it may be a day or it may be half a day. And we want to resolve these financial issues that you've just mentioned that may not be particularly simple in some cases. I'm going to want to get as much information as possible in advance and get to work a week or so before the date that we actually meet at your office. So I'll introduce myself to the other attorney and get the contact information for both the parties. And usually you or the other attorney will let me know this party's paying or whatever. This is how you're going to get a check, but I will need to get paid up front before the day we meet because I'm going to be doing several hours of work on the case, preparing the groundwork before we get together because I want to make the best use of that day. I'm wondering if you've worked with other mediator attorneys who gather financials beforehand, because I get the sense that a lot don't do that. I may be wrong.
There are some private mediators I've met with. They generally have wanted some information beforehand or at least some briefs from us. You have wanted, all the documents that you can get your hands on. Sometimes other attorneys have asked for just marital balance sheets that we've done ourselves and not necessarily asked us for the documents.
Right. Well, that's my personality, I suppose. But I find is a much better use of our time on the day of the mediation, which incidentally, in each of the several cases we've done together, has been held at your office. Logistically, that's made sense. Is that ever an issue for the other attorney?
No, they've always been happy to come here. I'm happy to go see to other offices as well. Um, we've done it here and it's been nice because I have other additional offices here. So when we meet all together, we can be in one spot. And if we need to meet separately, we can all be in different spots.
Yes, that's what's great about your office is we have these rooms where parties can go off and have separate conversations, which I think has been an integral part of each of the mediations we've done. Okay, so now for listeners out there, we I've been given some information, some of the financial information. I've put together a spreadsheet using with the software that I use. I've brought 5 copies, one for myself, one for each of the divorcing parties, and one for each of the attorneys. And we have an introduction at your conference room. And just to paint a picture for our listeners, I typically sit at the head of the conference table because I'm the new party here and I'm introducing myself and conducting the beginning of the mediation. And you're typically sitting on one side with your client and the other attorney on the other side with his client. And I'm curious what you might have said to your clients. You don't have to divulge secrets, but how you prepare them for the mediation. Because when I get there, the first thing I want to do is commend them for coming and commend them for being part of this process, which, if successful, and fortunately we have been, is going to be far less expensive, both emotionally and financially for them, and is going to put them in control of the process rather than having a judge dictate the division of their assets. I also reiterate the terms of the mediation agreement that they've signed, that my role is to be an educator and a facilitator, not a judge. And this mediation is an opportunity for them to kind of take the reins of their own settlement and put them in the driver's seat. What have your previous conversations with them been to prepare your client for mediation?
Well, I mean, it's certainly not anything that I want them to be scared of. I tell them it's serious in the sense of we're trying to resolve all issues, but I try to prepare them and say it's not anything to be scared of. Andrew's very kind, very wise, and it's going to be a calm discussion, and we're just going to look at the reality of the finances. And I just kind of tell them how it's going to go. It's not going to be me running the show. It's not going to be the other attorney. We're going to let you do what you do. And that we're just kind of there to advise and to make sure that we're not skipping over any assets or any debts, or that they're entering into anything that would be really unreasonable.
I'm so glad that you said calm because I know when I come to a mediation, I will sometimes meditate myself prior to the mediation and try and get myself in the most zen, relaxed, calm state that I can be, and to open it up with a smiling, welcoming persona, as I just mentioned, commending the parties for their choice of this process. Because I think by being calm and managing my emotions and focusing on the idea of solving their problem, that hopefully that mental state can transmit to the parties as well. And that because Lord knows people come with emotions to mediations. It's still they may be able to, they may be talking, but still may be tense. So I think there's a certain attitude that I try and bring, and I notice you bring as well, that we are calm and we try to put put the parties at ease, which is ultimately, as we all know, the divorce is likely the largest financial transaction in people's lives, and it's done in a situation of stress and emotions, anger, resentment, bitterness, sadness, what have you. The more we can regulate those emotions, the better ultimately the process will go. So I appreciate you mentioning the
Yeah.
calmness. So,
That I was just thinking of that movie, Wedding Crashers. If
oh
you
yeah,
remember that movie where it starts with the divorce mediation scene with Vince Vaughn, and it's really tense and emotional, and I don't know, just a lot of chaos going on. I don't know, that's not what our mediations
no,
are.
not at all, not at all. And I should watch that again. I haven't seen that movie in a long time. So this introduction, this is really the only part of the meeting where I'm doing most of the talking, just kind of reiterating why we're here and how the meeting is likely to go, and mentioning that okay, we're here, we're getting introductions out of the way, and then the next step is to review the asset, the marital balance sheet that I've compiled based on the information the parties have provided. And then noting that we will have individual meetings where we can speak privately and the parties can confer with their attorneys individually. And then we regroup to share and discuss proposals, air thoughts. And then in most cases, I think we've had a second caucus, these individual breakouts, where we review the proposals made at the regroup meeting, and we can get into that in a second, and then the final, and then hopefully we'll have a final meeting where we can iron out an agreement, and ultimately lay the groundwork for drawing up the paperwork. So that's where I introduce how the meeting ideally will go. But specifically, when we're reviewing assets, I think this is a very important part of the meeting because we need to make sure we're on the same page. We need to make sure that both parties understand what assets are in play. And as you mentioned, with respect to restricted stock units, vested, unvested, and the potential marital value of those, understand that there may or may not be marital value components to some or all of those units. Pensions. If one party has a pension, there may be a discussion that this pension actually can be calculated as a present value because it is a future income stream. So that's something. How quadros work, and from a financial planning perspective, if parties have 401ks that are being split and one party needs some funds, needs some money soon after the divorce, that they know that with a quadro you can take money directly from the alternate payee account and avoid penalties if you're under 59 and a half, if you do it before rolling it into an IRA. So these sort of educational issues come up during the review of assets, and that we're all understand what we're dividing, because I think that's very important. What are your thoughts when we're going over this review process?
I actually like that portion of mediation because you have intelligent questions, and honestly, we find some things that have been left out, not necessarily on your end, but oh, we forgot about this car or these fancy items that we have in our house that we want to divide. And then we've also gone through and we have change some values on things.
Right. Right. And I've found that in practically every case where we're reviewing assets, because I've been the one doing most of the speaking up to this point, this is an opportunity for them to speak. And this is where some of the emotions may come out through the assets. Well, that's mine and I'm keeping that. Or and
Right.
other things there may be you can kind of start to get a feel for the individual's personalities and their emotions and how the mediation might go. Um, with respect to things like retirement plans, and there are stereotypes about men and their retirement plans. It's like almost like the precious ring in Lord of the Rings. You're not touching
Right.
my retirement account, and that's when attorneys can come in very handy, very handy because well, a judge might beg to differ,
Right.
but you kind of get a feeling people begin to stake out their positions a little bit. And I find often in the asset review stage, I'm saying, okay, well, we can talk about that, or we can talk about that. Right now, we're just making sure we're on the same page and that we haven't ignored anything and that we understand how the taxation issues on some of the assets and how things work. Um, I think the really productive work starts next when we go to typically I'll stay in the main meeting room with one attorney and their party. And often that's based on how the review of assets goes. If I think I should really speak to this person first because, they're maybe tense or whatever. Um, so we'll have the individual caucusing, and that's where they open up about what their key concerns are, whether it may be the house or retirement plans or spousal support, or their thoughts about how spousal support should go or not go. So that conversation will be had. Mainly, this is where the client will do most of the speaking. Their attorney will have some words as well, and I'll listen and take down notes. What's going on? I'm curious because I'm in that room. What's going on when you go into the other room? We've done the introduction and the review of assets. There may have been some tension. There may have been some positions staked out. But while I'm individually caucusing, let's say, well, it can be the husband or the wife, doesn't matter. But you're with the other party in the other room, waiting for our conversation to
Yeah.
end so I can speak to you and your client. What's going on with you and your client at that time?
I mean, honestly, there's probably some chit chat about what just happened in the room, or, if we saw that the other side got tense about a certain subject, we're probably talking about that to a certain extent. But I've already talked to my client before mediation has started, and I kind of know where we're already going. So honestly, we're probably just talking about whatever might be going on in their life or work
Shooting
life
the
or
breeze.
yeah. So we're just kind of waiting.
Yeah, and I'm aware that you're probably waiting, and I'm aware that we want to get this resolved in that particular day. So try to hear the other party, but also smooth the process and get the process moving. So let's assume that there's been these individual caucuses where I've met with both parties and their attorneys, and then we regroup. And so we're all back in the conference room together. And my process is to try and recapture, and we may not have lost it, but let's re-emphasize the positivity of being here and having these discussions, and that we may not agree on everything, but to focus on having spoken to both parties, say, hey, we've got some common ground here. There are areas where I see that we can move forward, and you've both shown flexibility in certain areas, and that's good. There are a couple of areas where you may have different opinions, approaches, and we can talk about that. And then we might have proposals. At which point, one party may say, "Well, I'm willing to pay spousal support, but I don't want to pay it that long." And this is where things can sometimes get a little tense, and because they're still focusing on these problem areas, not so much the commonalities because they've kind of set the line in the sand. I need spousal support for 10 years. I don't want to pay spousal support. Okay. So this is where I kind of back up a little bit and the proposals are made and we hear out each party. I'm curious, let's say your client may have, I want to say, unrealistic expectations of receiving spousal support. And when I say unrealistic, I'm just going by what a judge may potentially offer. Let's say it's a 10-year marriage and they want to receive 20 years worth of spousal support. How do you how do you help in helping educate your client in that point?
Well, I just tell them, well, one about our law and Nevada law doesn't have any set magical formula on alimony, number one, but I can tell them general rule of thumb. And because I only do family law and I'm in front of these judges all the time, I can
Right.
also speak to them about their specific judge.
Yes, that's important. Yes.
And okay, well, for the last 15 years, I have seen your judge do this typically in these types of scenarios. And I guess I just have always approached clients that way, just really try to manage expectation, under promise and over deliver.
That's a very important point you made about when I said what a judge would say. Well, it depends on the judge because some judges may be more positive towards awarding spousal support and others may not. And these are human beings. They may have had their own personal negative experiences or positive experiences one way or the other. They may be going through life situations which render their judgment um, less than optimal, which is another reason why mediation, these alternative divorce resolution techniques are so important, is that you don't want to put your lives and all the details of your lives in the hand of one person after a trial who's maybe looked at the details for a couple of hours, who's maybe had a bad day, who doesn't understand all that's been going on in your life, to issue decision. And as I say at the beginning of the mediation, when we do it, I'm not a judge. I'm neutral. The opportunity here is for me and your attorneys to help facilitate the two of you coming to an agreement so that you can avoid the cost and time and stress of a trial and put yourself in the position where you have one person making these important financial decisions for the rest of your life. So I've found that in the mediations that I've done with you and other attorneys, that your role and the other attorney's role in bringing that point to bear on their clients has been very helpful, particularly in this regrouping session where proposals are being presented and the attorneys are saying, that may not fly with this particular judge.
Right. And there's, something to be said for all of that. So with the judge, but there's I don't even know what to call it, but just a overall benefit to come to resolution, not having to pay more attorney's fees, because then you're going to be paying both of us to go to trial. You're potentially going to be paying the other side's attorney's fees to go to trial. And just that interim period, for some courts, it might be an additional 6-9 months that we're out. Just that waiting period, that stress, that anxiety, there's a benefit to just getting it done and being the decider of your destiny.
For sure. For sure. And when we're doing the mediation, we've had this regroup, and then we go back to the individual caucusing or breakouts, and clients, you know, you get the feeling that they understand, okay, maybe the position that I've staked out's not going to fly, but I've seen some willingness on the part of my soon-to-be ex that they're willing to be accommodative here. This is where I found in the individual breakout sessions that really it's a conversation. I'm just watching the attorneys have a conversation with their clients, and this is where I see you guys doing the important advisory work. And maybe offering some compromises so that when we get back for what is hopefully the final regroup, that we're actually pretty close. And once again, when we do get to that final regroup, that's typically where I'm feeling that we're almost there. And it's like, and that's a point that I want to convey to everybody. It's like, we're almost there. You guys have done a great job. You've shown flexibility. I know this isn't easy, but it's 3 o'clock in the afternoon. We've been here for 5 hours or whatever. Um, and we're really close. And I think that that there's been positive momentum, that we found some positive momentum in those more difficult cases to try and find those positive nuggets. Ultimately, can bring us in that regroup to the point where this is where it's a conversation across the table between you and the other attorney and their clients, and they're kind of saying, "What do you think? What do you think?" And that's where the magic happens, and ultimately the resolution of the magic anyway, and where we can come to an agreement.
Yeah, so I mean, at that point, now we're having more serious discussion when we're meeting by ourselves. And now I kind of know, okay, where is my client kind of like that higher limit willing to give? And, where should we kind of start at?
Right.
And I know that I can negotiate within that realm. And then I think, we would quickly know if there's going to be no agreement. But with you, I've never not had an agreement. But I guess just in general, from a mediation standpoint, you can kind of tell if the clients are so divergent
Right.
that you're not going to come to an agreement. And that's not a case I would suggest go to mediation when you can tell that they're so divergent. When I'm calling you, I know that we can come to compromise.
Right. Yeah, I was going to ask you about that a little bit later, but thank you for bringing up what's going on in your second individual caucus because you're no longer shooting the breeze.
Right.
Important issues have been brought up in that regroup, and this is where you're discussing with your client. Are you flexible here? What should we ask for here? And this comes out of the final regroup. And fortunately, in the cases that we've worked on, we've been able to hammer out agreement. Now, when that agreement happens, what's the next step? Drawing up the paperwork. And typically, what do you do there?
So what I did at this last mediation with you and what I've done at mediations at like where I haven't had a mediator present is I like to record it. We've just had a long and exhausting day coming to resolution. I like to just notate like what all the terms are and just identifying everybody who is present and what those agreements that we've come to. And then one of the attorneys is going to subsequently draft up all the paperwork for that.
Great. And then how quickly does that process take after the mediation, after we've recorded that and you agreed to draw up the paperwork? How long before the documents are drawn up, they're presented to a judge, signed, and the divorce is done?
So, I mean, that can sometimes take just depending on schedules and all of that. Sometimes we can get it done lickety split, like within the next week or two. Sometimes it takes a little bit longer. And, just you can kind of sense too where the parties are at. Like if they're just so done and you can tell they don't want to wait anymore, like maybe I'll stay up really late, over that next week and just get it
Right.
done for them
Right, right.
for ease of mind.
Yeah, it's terrific. You mentioned a moment ago when you call me with a case that you think these people are well suited for mediation. Not all your cases are mediated. I know that you do trials as well. What do you find are indicative of the cases that go to? I mean, I can guess, but for our audience, from an attorney's mouth, what what gives you hope that that a mediation can be successful versus a case that these parties that's not going to work?
It's usually a mixture of the other party kind of coming to learn their personality as well as the attorney that they hire.
Right.
I know all the attorneys and which ones are truly willing to sit down and be totally fair.
Well, that's just it. When divorcing parties, either individually or together, typically individually contact me before they've hired an attorney, I try to get a feel for how they are relating to their spouse, how complex the assets are, how contentious the divorce is. And then I'll recommend some names to them and say, well, in this case, you might want to contact this attorney. But I can see if you're dealing with a, hardcore shark litigator, a mediation's probably not going to work.
Right.
So we've talked about this process being less costly. Let's get into some nitty-gritty details. I know for my part, I typically charge a flat fee of $3,000 to $4,000, depending on the complexity of the case, to do for my role in the mediation. How about you, and what do you think about the other attorneys as well?
Um, Honestly, a lot of other attorneys charge more than me. Um, I try and do mediation towards more of the beginning phase of the case. So this is not usually something I'm trying to do after we've already had trial set, that kind of thing. So for that portion of the case, I'm usually $7,000 range, and I've been flat fee. I'm going to be incorporating some changes this coming year. Um, but usually with that fee, I am producing all of the necessary documents under our rules. We have Nevada Rules of Civil Procedure 16.2, where I need to give disclosures to the other side. I need to disclose all of these accounts. Um, and so I turn around and I give you that work that we've already done. So at that point, they're paying money, but they're not paying trial money at that point.
Well, for sure. And I think $10,000 is along the lines of pretty much in line with what a mediation would cost a party. Um, and honestly, given what I paid in my divorce, which didn't even go to trial, but it was multiples of $10,000, and
Right,
it didn't go to trial. And if it had gone to trial, it probably would have been double the multiples
right,
of the cost. So d divorce is going to cost you some money, but Lord, you don't want to do it yourself,
right,
particularly if there's complex assets, because I think the worst possible thing, and I've done a separate podcast on the dangers of do-it-yourself divorce,
right.
is that if it's not done properly, you don't want to relitigate it 5, 6, 7 years down the road when you've started a new life for yourself.
Exactly. But yeah, the especially when you have complex assets and every divorce, not maybe not every divorce, but I would say the multitude of divorces, you have your emotion involved. You're upset, you're stressed, you're anxious, you're all these things, and that clouds judgment.
It certainly does. And there are techniques. I mean, I'm not there. I mean, I do incorporate techniques when I'm dealing with people going through these emotions, and I mentioned the calmness and trying to convey that. Um, but and letting them know I'm not a judge. But there's a great book by a noted mediator by the name of Bill Eddy. It's called "So What's Your Proposal?" And every time we do a mediation, I review that book and I look at the certain language that he recommends, and he uses phrases, particularly when you've got people who are, getting upset and argumentative. He suggests using phrases like, "Well, so Ed, what's your proposal?" Or "What would you suggest, Susan?" Or "Sally, what are some options you'd like us to consider?" I'm interested in hearing your thoughts on the subject. These sort of phrases, I think, and I've used them, can often help bring those emotions down. So there's a bit of a bit of an art and a science to the process of mediation that helps in reducing those emotions, which we know are not what you want to bring to such an important financial transaction.
Right. And you've used those during our mediations. And then that is where having, I think, two attorneys in the room and we're not contentious, but sometimes that client is still being like a little bit unreasonable to a certain extent, not bad, but a little bit unreasonable. Sometimes it helps them to hear it from my position too. I'm sure their attorney has already told them the same thing, and now they're hearing the same advice from the other attorney. Like, oh, well, I don't think that's the most reasonable request because of XYZ.
Right. Right. And having a settlement-minded attorney such as yourself and the other attorneys who've been involved in the process can help contribute to bringing down the levels of emotion and leading us towards a settlement, which is what we really want. Amber, we've gone over the half an hour, rather quite a bit. But thank you very much. It's been very educational for me to know what's going on with you and the client, and I'm sure for our listeners. If now you're licensed only in the state of Nevada, correct?
Correct.
All right. So if any of our Nevada listeners are interested in contacting you and availing themselves of your services, how can they find you?
On socials, you can find me at Family Lawyer Las Vegas. My website is familylawyerlasvegas.com, and it's 702-527-2625.
Terrific. Amber, thank you very much and Happy New Year.
Thank you, Andrew. Happy New Year.
Thanks so much for tuning in to this episode of the Great Divorce Podcast. To learn more or get in contact with your host, you can visit Andrew's website at transcendretirement.net. Also, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show, and we'd greatly appreciate it. Thanks again for listening, and we'll catch you in the next episode.
Information provided is educational only and should not be construed as legal or tax advice. Each situation is unique and should be discussed with your tax or legal advisor prior to implementation. Andrew Hatherley is not an attorney and does not provide legal advice. Information provided is financial in nature. Advisory services offered through Hatherley Capital Management, LLC. Divorce financial analysis services offered through Wiser Divorce Solutions, an affiliated company.